This is Barry Zalma on insurance. I'm an attorney who has retired from the practice of law and now spend my time as an insurance claims consultant, expert witness, and author, and producer of these videos. Today I'd like to talk about exclusions to coverage on insurance policies that insure construction defects and contractors and builders of structures. Implicit in the concept of insurance is that the loss occur as a result of a fortuitous event, not one planned, intended, or anticipated. Oddly, the fortuity principle never appears in insurance contracts. The principle is rooted in common law and in the statutes of at least 6 states. The fortuity principle has the effect of an exclusion that is not written in the policy itself. That is, an all-risk policy might provide coverage for all risks minus named exclusions, but never provides coverage for non-fortuitous events, even though non-fortuitous events are not named exclusions in the policy. For this reason, the fortuity principle is sometimes called the unnamed exclusion. A fortuitous event is an event for which, so far as the parties to the contract are aware, is dependent on chance. It may be beyond the power of any human being to bring the event to pass. It may be within the control of third persons. It may even be a past event, such as the loss of a vessel, provided that the fact is unknown to the parties. This was a decision called the Compagnie de Bauxites de Guinee versus the Insurance Company of North America, a 1983 decision of the Third Circuit Court of Appeal. The purpose behind the fortuity doctrine applies with full force where a party attempts to purchase insurance against the consequences of his own ongoing wrongful conduct. To avoid determining whether or not there is a fortuitous or non-fortuitous event, most commercial property and general liability policies include intentional acts exclusions. Judge Cardozo, one of the most famous of all U.S. jurists, in 1923 stated a simple and obvious rule of law that no one shall be permitted to take advantage of his own wrong. California, by statute, has codified Cardozo's statement. Almost every insurance policy issued in the United States excludes the intentional acts of the insured. Those that do not are covered by the public policy adopted by most states and the fortuity doctrine. To insure against wrongful acts would be to allow people to act wrongfully with no adverse effect, since their victims would be compensated by insurance. Insurance involves, of course, the transfer of the risk of possible losses from the policyholder to the insurer. It is not available for losses the policyholder knows of, plans, intends, or is aware are substantially certain to occur. Insurers faced with a construction defect claim may attempt to exclude coverage by claiming that the insured intended to build a defective structure. This is not a wise option to exercise unless the insurer has clear and convincing evidence of such intent. The standard occurrence definition excludes coverage for injury intended or expected by the insured, and incorporates the fundamental concept that fortuitous loss is a prerequisite for coverage. Although the intentional act exclusion was once considered the unwritten fortuity exclusion, by putting it in writing, it makes it easier to convince a trier of fact that a loss is not fortuitous, and if it is not fortuitous, it is not insurable. You cannot, for example, insure against your liability for defective plumbing that leaks continuously after the leaks begin and the plumber is advised of the defect any more than you could insure against the loss of your house by fire the day after it burned to the ground. Since most of the acts performed by a property owner or other person involved in the creation or use of improvements to real property for construction defects, if they are intentional, the intentional act exclusion often raises unnecessary concern. The intent required by the intentional act exclusion is not an intent to build the structure, but instead an intent to do damage to that structure. No insurance policy can provide coverage for acts intended by an insured to cause injury. Basic insurance law requires that the incident that is the basis of a claim arises from a fortuitous event. The fortuity doctrine arises from the basic concept that insurance covers risks, not losses that were planned, intended, or anticipated by the insured. A construction defect claim seeking damages because, for example, windows leak and allow water to enter the structure, is a fortuitous event since, as far as the insured developer or contractor was concerned, the event is dependent on chance. It was unknown to the insurers until it was reported by the injured party. The contractor or developer did not plan on or intend that the windows would leak and cause damage to the occupant. The claimed loss, therefore, would be fortuitous. The intended expected concept has been moved from the definition of occurrence to the part of the policy that lists the risks excluded. Occurrence is no longer defined as neither expected nor intended by the insured. The exclusion explicitly does not apply to bodily injury resulting from the use of reasonable force to protect persons or property, so coverage may be afforded in such a situation. Exclusion A to the basic commercial general liability policy provides, quote, bodily injury or property damage expected or intended from the standpoint of the insured. This exclusion does not apply to bodily injury resulting from the use of reasonable force to protect persons or property. It is difficult to understand whether the change was made as a matter of form or to return the concept of accident to the agreement unmodified by the expected intended wording. The new wording does not address the following questions. What is a reasonable force? And must the protection be lawful? The new CGL does not deal with the problem of the intended act leading to the unintended injury, and it fails to clarify the difference between objective and subjective intent. The California Court of Appeals stated, quote, the existence of a preconceived design to injure is relevant only when mental capacity is at issue or the insured's intent or motive might justify an otherwise wrongful act. Thus, California Insurance Code Section 533 precludes indemnification whether or not the insured subjectively intended harm if the insured seeks coverage for an intentional, wrongful act that is inherently and necessarily harmful." Close quote. The basic CGL policy excludes coverage for intentional acts but has an exception to the exclusion. For example, a builder is on a building site to investigate a claim of defective construction. The builder notes that a roofing tile was not properly installed and is about to fall. Intentionally tackles a tenant, breaking the tenant's arm to keep the falling tile from striking the tenant on the head. In this situation, coverage might apply for the intentional act. Similarly, while the new buyer is on a construction site, two contractors get into a fistfight because one claims the other did his work defectively. The fight grows and puts the buyer in danger. If the job superintendent punches the two contractors in the nose, injuring them but protecting the buyer from injury, coverage may and properly will apply. However, if there was no effort to protect someone else, the intentional act and the injuries caused by it would not be covered. In Pennsylvania, for example, intentional acts are not insurable. The court stated in Erie Insurance Exchange versus Fiddler, a 2002 decision of the Appellate Division of the Superior Court, quote, "In this case, appellant sought coverage of damages allegedly caused when young Fiddler threw young Denslow against a wall and into a desk. We agree with the trial court's determination that this was intentional conduct as a matter of law. We have previously held that such damages are not covered when the policy excludes damages expected or intended by the insured. There can be no doubt that Fiddler intended the same general type of injury as resulted here. Self-defense is a defense to a battery. It is recognized by both criminal and tort law that a person has the right, without liability to the other person, to defend him or herself from injury due to intentional acts of another. This does not, however, change the character of those acts from intentional to accidental acts. When a structure is defective, it can cause injury to the occupants of the structure. The occupants are entitled to protect themselves from such an injury and may seek recovery from the builder of the defective building for actions to defend or otherwise protect themselves or others from injury due to the defect. The builder may also act intentionally to protect the occupants of the structure from injury, including intentionally evicting them from the premises or forcing them out of the structure to protect them from potential injuries due to the defect. Exceptions and exclusions in an insurance policy are and must often be construed liberally in favor of the insured. Doubts as to meaning will usually be resolved against the insurers. Courts will only apply an exclusion if the wording of the exclusion is clear and unambiguous. An intentional act to the majority of the courts is an intentional act, regardless of the motive of the actor. People involved in the design, construction, or ownership of improvements to real property should not expect to be defended or indemnified by an insurer for acts that can be established to be intentional. The minority of courts, however, do provide coverage looking beyond the clear and unambiguous terms of the contract to create an exception to the intentional acts exclusion if the insured acted in self-defense or negligently. If a plaintiff claims that the construction defects were created in an intentional cost-cutting scheme, the exclusions would seem to apply. However, the insurer may not limit its decision to the allegations of the suit, but must conduct a thorough investigation to determine if there are facts outside the suit that the real cause of the damage was negligent construction, and if so, that it is clearly covered. Some insurers will attempt to claim that a construction defect claim was not fortuitous if the defect is so bad that loss was inevitable. This attempt should be resisted strenuously, since the injury that actually occurred was fortuitous, even if the damage to the real property was inevitable. This video was adapted from my book Construction Defects in Insurance Volume 3, which is available as both a Kindle book and a paperback from Amazon.com. If you found this video to be useful or interesting to you or your colleagues, please pass it on. It's free. And please subscribe to my YouTube channel, my Rumble channel, and my blog so that you can learn of future videos and blog postings. Thank you for your attention.